Hi, this is Joanne, and our compliance tip today is release of information and psychotherapy notes. Answer this question. Does HIPAA provide extra protections for mental health information compared with other health information? Yes, there is an exception to the general rule, and that is for psychotherapy notes, which receives special protection. The privacy rule defines psychotherapy notes as documentation recorded by a healthcare provider, and the contents contain conversations and notes that are typically recorded during a private counseling session. Now, this counseling session can be a group, individual, or family counseling session, and they're kept separate from the rest of the patient's medical records. Psychotherapy is the treatment of mental illness and behavior disturbances. Psychotherapy notes are defined as notes recorded by a mental health professional which document or analyze the contents of a counseling session and that are separated from the rest of the medical record. Now, there is an exception for psychotherapy notes as they are very private pieces of information that receive greater protections against disclosure if they meet the strict definitions set out in the HIPAA rules and are kept separate from the remaining medical record. The definition of psychotherapy notes excludes the items on this particular slide, like medications, start and stop times, modalities, test results, functional status treatment plans, symptoms, prognosis, ongoing progress, and progress to date. That's not what a psychotherapy note is. Those are not excluded. Those items on this slide are needed for reimbursement purposes. Remind providers, we need to keep this information separate from the medical record. Psychotherapy notes are the personal notes of the therapist. Check with your EHR vendor regarding electronic options to keep these notes separate so you are not required to submit them to a payer for review upon audit. Don't provide psychotherapy notes even upon receipt of a subpoena. First, talk to your attorney. If your work for an institution and your institution is the holder of mental health records, you should speak to a supervisor who should then pass the issue on to legal, employed by the agency, to look at the situation to see if there are any ways to not release those very, very private notes. In summary, follow your state and federal guidelines. Check with legal counsel and your risk attorney affiliated with your malpractice insurance company prior to releasing any sensitive information which could be classified as a psychotherapy note. You should not be releasing psychotherapy notes, even with a release of information. Remind providers treating drug abuse or mental illness to keep personal treatment notes, which classify as a psychotherapy note, separate from the regular progress note and chart. Thank you for taking time today to review this compliance tip video and consider additional training. I highly recommend our comprehensive clinical documentation improvement course so that you can earn your CMDP credential through the American Institute of Healthcare Compliance. What are you waiting for? Start today.